Are live. This broadcast, we'll be holding and introducing some information to some people and clarifying some information for others. And what we are holding in this broadcast is a unique display of the information that's
I couldn't grow higher than 5 a step, but
also we have uh, uninterrupted ads.
after spending around $600, I found a solution to be taller. After trying 12 different...
The reason for that is because it contaminates your content when you have uh, good content cluttered with um, a bunch of ads and so forth, and potentially your viewer is not going to even patronize that item. That's a waste for the person who's paying for advertisement, and it's a waste of time for the viewer who's intending to consume your content. In other words, you probably could get your likes up if you had uninterrupted content. But this particular video is about the 1099. They're stating that they're actually in real time reporting what's going on with participants on their platform to help others from making mistakes, and also understanding how the systems work within the scope of the particular acquisition that you're trying to make. If you're trying to acquire abandoned property, then you would be doing both and one in the same. So, in that regard, that would require for you to fill out in additional forms to distinguish between the acquisition aspect of the A, and then you would have separate documents to um, distinguish that you are submitting documents in relation to an abandoned property. So you want to distinguish that. Which one are you doing? And sometimes you're doing both. Okay. What I mean by that is you're acquiring what may have been deemed as abandoned property. Okay. So that's descriptive of both aspects. Let's get it.
So keep in mind, guys, that the instructions themselves have quite a bit of information. And two, again, it's legalese. A lot of this stuff is not easy to understand the first time. Like I said, I still have to keep reading this stuff to grasp it, understand it. But the more and more I read it, the more I realize like it all starts to make sense. So today I'm going to go over what I currently understand. It's not going to all be accurate because there's still information I don't fully understand with this stuff, guys. That's why I'm still reading through the instructions and I'm still trying to understand the difference between both of them, right? So it's one thing to have a really good general understanding of this, but then it's another to really know how to use them in very unique situations, because what you'll notice is as I go through certain parts of the instructions, and I'll highlight specifically which ones I've been paying a lot of attention to. I've also found some common themes between these forms and how they're supposed to be used, and I'll be covering that. But then also, I'm going to be sharing the notes that I've been using to really just dissect the 1099A and 1099C. And my goal is to help you guys get a different perspective of how this stuff works based off how I've read it, okay? And if any of you have submitted a 1099 or have successfully processed the 1099C or A, don't hesitate to, share some of your experiences. I will say that I've just only had experiences with dealing with it from the IRS standpoint. I haven't had to actually complete the entire process. I've just gone through the transcripts, learning where to find them and identify where to begin, and then just really reading through the instructions to know what to put, right? And I found some examples from some of the mentors I learned from on how to fill out the 1099s. So I'm going to share those with you here. But for now, I'm going to just cover the general basis of the instructions, right? And
Wow. So he was very clear with you. He have not filled out none of these forms. And so it's basically a guinea pig platform, okay? And he's using wisdom to um, basically disclaim that he does not have any.
so, in case you guys are wondering where I got this form,
Um, he's letting you know he does not have any personal knowledge as to these processes. He's asking you for your personal knowledge to contribute to his database. But he is claiming to not have any knowledge of or any personal knowledge of processing these documents himself. Okay? Now, that is very wise that he is gathering information, allowing other people to make mistakes and kind of stand behind the scenes and see who's brave enough to submit these processes and see what the outcome is going to be. And meantime, in between time, he actually reading the instructions so he can learn what the documents is for himself. I would recommend that. Um, that's essentially um, what the process that I took before actually doing anything. I did some research first and then act. Okay. This is why I was able to avoid just jumping into doing people's processes and having adverse reactions to it. Because I understood that some people carelessly put information out and recommend that you do certain things. But I also am utilizing the value that's in the comment section. If a person cuts off their comment section, I am assuming one of two things. You cut the comment section off because you want me to just pay attention to the audience, to pay attention to the content, or you cut the comment section off because um, somebody was exposing that your content was invalid. Okay, so just consider that when you cutting that comment section off of how people are viewing you as maybe some type of con artist. Okay, you don't want me to make comment about this content. It's got to be something effed up in it, and move right along. Um, and so that may decrease your viewership, even if you do have legitimate content. Okay, I really don't like to watch videos that I can't make no comment on myself personally. You ain't gonna force me to watch your video and then I ain't even have no say so to say nothing about whether you wasting my time or I appreciate the content or nothing. That's narcissistic in a way. But like I said, whatever, it depends on the reason you did it, okay? You might be zoning your traffic elsewhere. Okay, maybe you want to zone your traffic to a certain um, post or something, and you don't want them to comment on the video so that you can have all your comments in one place. There's an honorable reason. It's just good to let people know what's going on so they be clear in contracting. Okay, moving right along, we gonna go ahead and allow him to explain what he have gathered so far in his learning process.
Got it from the IRS, irs.gov, and all the information that you need is here. So if you're looking for general instructions, it's all in irs.gov. That's where I got it, right? And it's not long, right? It's a little bit different, right? When you're dealing with
No, he ain't even said nothing. He got a commercial. See,
Kroger same day pickup and delivery. Texans can shop the same in-store price.
he ain't even said nothing. So he
the
just
1099C and A,
he
it's
just
6
started a
pages,
good subject
right?
to
Versus the OID, right? The OID is, I believe, 26 pages you got to read. And then the 1099 publication, for all 1099 forms, that's like 100 and something pages, right? And the 1099 covers all of them. It covers the 99A, the C, the 98, the 1096, right? It covers all of it. But there's so much to read out there, guys. And this is why it's important to understand that by taking the time to dive into one thing at a time, it's going to help you in your journey because it's all one big puzzle, right? It's like you're taking a puzzle and you're trying to put it all together so you can see the clear picture. But right now, this is just one piece. The 1099A is one piece to the C, which leads to something else. And as you keep diving deeper into these instructions, you'll start to realize how they're all interconnected, right? And like I said, I'm just in the beginning of this. I'm surface level, and I've learned a lot, right? I've learned a lot really, studying this, and that's how I came up with a lot of this. Like, my close friend is currently going through a discharge for his car, right? And he went through this process, and just to find out his car came back and got repoed. So now they're going back and filing the 1099A, right? So I'm close to people who are actually doing this in real time. Although I may not be doing it, he's sharing this stuff with me. He's like, man, like I ran this process and I missed the steps because his car is financed, and because it's financed.
all right. So we on crash dummy mission 1 at this point. Okay. And so this seemed like a uh, gimmick, not a gimmick, but a lot of people are indulging in this as they are teachers. And even on this, he didn't say he was a learner. He said this was a university, E&A University. He didn't say he was an amateur trying to learn nothing. That's a deceptive business practice. Okay? People need to be aware that you're going to run into people like this. They going to crash dummy mission your ass. Just don't indulge. It's a waste of your time, okay? Now,
scumball, beginner, mumbo jumbo. Okay? You got.
That's exactly what it is. So we're gonna run this shit back, and we're gonna let a goat speak on this matter. All right, he gonna tell you like a GO.
All right, I'm not doing that. Okay, you just have to really understand how many people like yourself has tapped in with this service, and I damn sure would tap in with the service too. All right, you mean to tell me I can just pay somebody to assist me with the administrative process on the private side and the public side? Because you know how many people are strictly only teaching the private side? You know how many people are just only teaching the private side? Why nobody teaching the public side? Why nobody teaching that you have a left hand and you have a right hand? Okay? So again, we're doing the private side and the public side, assisting you on whether it's an old car, a new car, a current mortgage, a new mortgage. All right, you don't gotta trust. We have trust services for you. Okay, literally. Now, granted, the only thing is we want to reach 21 days and be able to have your wave 1, your wave 2, your wave 3 completed. All right, that's literally what I've been building on. But as more and more people have tapped in, family, all right, those turnaround times have expanded. All right, and again, I apologize. I know a lot of you in the your DM saying, "I'm getting scared. I sent you money. I still don't know what to do." And I always ask, well, after you sent money, did you fill out the information form that you're supposed to fill out? All right, especially if you have a current mortgage, because after you send money, you're not supposed to be waiting on me. All right, after you send money, you're supposed to fill out the job form, information form that we send you, so you can give your first name, last name, so you can have your address on there as well, and then you're supposed to upload your current mortgage or your current car contract. All right, or if you're signing up for our services for new acquisitions like a new car or a new home, okay? All right, you want to be able to upload either the purchase agreement from the new home or the buyer's order from the new car. All right, now if you didn't receive that form, that is our fault. Okay, I'm gonna say it again. If you did not receive that form after you paid, it is our fault. Okay. So we apologize. All right. If you did not receive that form, please come back to our DM to let us know, hey, I did not fill out an information form. Because family, if you didn't fill out an information form, you are not in the queue. All right. Yes, I know you paid your money, but if you do not fill out that information form after you pay your money, because it literally says that in the payment, it says after you pay, submit your documents and submit your name. All right. All right, but if not, it's basically your name is not going to be getting brought up for our reps that's doing these contract reviews. All right, so again, I apologize, family, for not making that clear. I put it all on myself. All right, but one thing we're not doing is taking anybody's money. All right, even though you sent it through Cash App, if you sent it through Zelle, we just need you to take a screenshot of your proof of purchase. Once you fill out the information sheet form, you also need to show us that you've already paid, show us proof. All right, and we can go from there. All right. What else? Oh yeah, security interest, family. That's really what we are pushing over here from here on out. We're talking about the public process. All right. Now, again, there's a lot of people that teach us about private process, how to not to be in the public. You don't want to be in the public. You don't want to be in the public. You don't want to be in the public. Not understanding, okay, what if we're getting beat up in the private? We have to bring it to the public so we can get help. Okay, no matter if you operate in trust, equity, consumer law, it doesn't matter. All roads lead to court, family. If your person that you're listening to is not asking or not teaching you about courts, all right, you have to understand on your own, you need to learn the court side, okay? Again, that might not be their responsibility to teach you the court side. They might be supposed to teach you the private side. You need to understand, okay, I've learned everything I need to learn from this person. Now I need to go learn how to litigate. Because if you do not know how to litigate, you will fail, family. All right? It's just going to be practice. Practicing and practicing and practicing. And some people say practice makes perfect. Not if you're practicing wrong. Not if you're practicing wrong. All right. We also have credit card services. All right. We also have credit card services. If you would like us to assist you with leveraging your security interests on your credit card, family, because it is legal, family. It is legal. All right. I know people are scared to talk about certain things. It's only because they don't know the full process. You're not scared when you understand the full process. We can talk. All right. If you would like to leverage your security interest in your credit card, we have services. For those that have already signed up for those services, buckle up. All right? Because I know a lot of y'all just looking at the end roll. Oh my gosh, I'm about to be able to use this card. Like, yo, you better know how to basically stand over this documentation that we're assisting you with. All right? Because when you go to court, when you have to go to your hearing, I'm not standing there with you. Okay, it's you. It's you and your documentation. That judge is gonna ask you, okay, sir, how is this money? Did you pay? And you got to know how to go up there and say yes. As you can see in my documentations, Your Honor, I have performed. I performed with legal tender. All right, as you can see in my wave 1, you can see there's a bill of exchange, there's a tender of payment, there's conditional acceptance, there's a truth of affidavit of truth, and most importantly, Your Honor, there's an affidavit of claim to security interest. By showing that I am the secured I have priority rights over the secure collateral, all right, because I have made a claim to it, Your Honor. All right, as you can see in my wave 2, they did not answer. All right, they could not answer, Your Honor. They did not answer. They have rejected, or they basically went silence when I gave them an opportunity to cure. All right, as you can see in my wave 3, Your Honor. All right, I got all the way to a wave 3 to in my administrative process. I got to a wave 3 because they still didn't answer. I still have not received benefits of the collateral that I have a secure interest in. All right, and that is why the account is reflecting default, Your Honor. So it's not a fact of me not paying. It's the fact that the opposing party is not performing their fiduciary duties. All right, and that is reflecting from the account. All right, Your Honor, and that's why we have us a cold case of breach contract, or a cold case of unjust enrichment, or a cold case of security fraud. All right, this is a mismanagement of security, Your Honor. All right, now that judge might turn around and say, well, what do you mean? How was what you sent them money? Okay, you're gonna ask, well, how was this money? How was these stacks of paper that you sent? How was it money? Well, Your Honor, great question. It's money because it's legal tender. All right, pursuant to UCC's Article 1, Articles 3, and Article 9. All right, it basically compiles how negotiable instruments can be used for discharge. All right, and what happens when a negotiable instrument is refused? All right. Okay. Now remember, I don't even have to bring in the Federal Reserve. I see a couple of y'all saying Federal Reserve, because if it's a credit union, I can't bring up the Federal Reserve. All right? Because the Federal Reserve does not operate with credit unions. All right? That's the NCUA. So we're keeping it on UCCs. All right? Because credit unions operate under UCCs, national banks operate under UCCs, state banks operate under UCCs.
What he's speaking about is correlating jurisdictions. Okay? That what he's saying is that he picked a jurisdiction which no matter which way they try to go with their defense, they kind of boxed in based upon the jurisdiction that he chose to bring the matter up in. The plaintiff brings up the jurisdiction, okay? So he chose a jurisdiction that the plaintiff cannot escape responsibility, and it zones them to jurisdiction that's compliant to common law. Now, whether he knows that or not, that's basically what he effectuated by choosing that to isolate that particular. He's isolating jurisdiction. As with when you um, fill out your complaint for your sworn complaint for a court case, they're gonna ask you what gives this court jurisdiction. Or I'm not sure if they asked you that, but it's a section on there where that is what that section is for. Okay, for you to explain how does this court have jurisdiction over this matter, and you are to explain what type of jurisdictional barriers you would like for the court to hear the matter uh, within the jurisdictional confounds of bills of exchange. Okay, and I think I even seen that as an option on the federal court um, cover sheet as an option, bills of exchange. Okay, they have contract, breach of contract as an option. Okay, and you can select, when you select both, that is alerting the court that this is a matter that's concerning a breach of contract related to a bill of exchange. So I don't understand what court he was in where he had to explain what a bill of exchange was. But if I was in a court of incompetent jurisdiction, I wouldn't even answer that question because I'm not here to educate the judge. The judge has placed himself in a seat um, to be predetermined as being knowledgeable, being able to hear this matter. No, I'm not finna teach a judge what uh, instrument is and what a bill of exchange is. And I'm gonna tell you why I'm not finna do that. That's counterproductive. I would submit a case to say that I would tell the judge, Judge, no disrespect, but it was my understanding that I was submitting these case before a judge with competent. So if you don't know what a bill of exchange is, then you anyone is I was incorrect in stating that this court was the proper venue and proper venue, because you mean to tell me you didn't had experience in court and you don't know what a bill of exchange is when courts are made of bills of exchange? And yes, you do have to be detailed as to what was the steps in solidifying your particular security agreement by use of the bill of exchange, but you shouldn't have to explain the bill of exchange to the judge. You cite it, and it should be explained in your case um, for the purpose of a jury. If you're going before a jury, if you choose a judge of what they call milk court, and you choose a judge or a panel of judges to hear your case, These motherfuckers better not come up here talking about they don't know what a bill of exchange is. They don't even have the proper authority to hear this competence uh, uh, to hear this matter. It's not the authority that they don't. Well, yeah, they don't have any authority or competence in the matter. It's not their position that gives them the right to hear the matter. It's their competence, what they call their degree of knowledge, to be able to weigh everything out. If they don't have some degree of knowledge for themselves, to the point where you have to explain that to them, then that's equivalent of not being a court of competent jurisdiction. That's the prima facie uh, description of not being a court of competent jurisdiction. I mean, you need to take this to somebody else because they don't know what they're doing over here. Okay, perhaps it's just that judge. Well, I would not even want to continue my case with you if you don't know what a bill of exchange is. I would like to change out judges. If y'all have another option I can choose here, or maybe someone of competent jurisdiction, because that was my intent when I submitted my documents. I was submitting it to a court of competent jurisdiction, was my intentions. And so, oops, my bad. I can either withdraw or y'all can come up with me somebody that know what a bill of exchange is and we can do business. Otherwise, I need to take my case somewhere else. You don't let them rule out your case when you can rule them out. Where they do that at? Why would you sit up there and let them rule you out? Rule their ass out. Okay, I deem you incompetent and unable to be a effective tool in this process. Okay, and the process that they are effectuating is involving finances. So if you fuck this up, then now I'm gonna have to add you to the claim and as a defendant as well, because now you costing me money because you incompetent and you trying to hear a matter that you don't have competent jurisdiction on. You don't have sufficient uh, understanding to which to draw from a judgment in this matter. Your degree of knowledge is irrelevant in this matter. If you are not even aware of any common law, if you are not aware of the postal rule, I gotta explain that to you. Well, what if and what if this and what I done seen judges do that. I'm saying, what if you don't be a judge? How are you gonna judge a matter and you asking all these questions that I can understand if it was you're asking specifically from them what happened, not a judge asking asking a lawyer how their case is right when a lawyer gonna always see it their way. I done seen judges almost flat out tell them you need to stop. You're embarking upon some dangerous ground. Stop. Please stop. You're doing too much. Let this shit go. You finna be sanctioned. All this kind of stuff. And they just continue and continue and continue to speak. Okay. So why would you, as a judge that's supposed to be one that's um, referred to as honorable, your honor, why would you place your honor in the hands of a liar? That's why that judge say you just need to stop. And so what are you expecting us to do? And put the ball right back in his court while he trying to get the judge to do something unethical, and it's so plain as day on the record, and then he's still trying to explain his way like it'll be all right. It'll be all right if we do this. We do this all the time, Judge. Are you serious right now? That's basically what he was hitting up to the judge. We do this all the time. It'll be all right, Judge. Judge wasn't going for it. Judge put his ass in timeout like a motherfucker. Um, he needed to stop and regroup and digress, but he never did. So that's why I don't. Now that was a respectable, competent judge, but you have some that sit there and listen to this nonsensical argument because they have some level of dishonor in them. They're sitting on the bench and they are really not knowledgeable of uh, jurisdiction, constitutional grounds. And when it comes to standing, when a person raises standing, 10 chances one they supposed to win. The reason why they supposed to win is because you can raise standing at any time. Any time. However, if a person raised standing too late in the game, you kind of pedaling against the tide because it's always going to be that question of why didn't you do this already? Even though you can do it now, but why didn't you do this from jump? To raise standing and say, look, I have standing before this court in a case for a bill of exchange, and I will need a court, a judge with competent jurisdiction to hear this matter and be specific when you place your petition before the court. That way, I'm thinking that way that would may eliminate your case being assigned to a judge. I don't know. They don't read the cases. I don't know. Okay. But when they do read it, it'll be understood that he need to come to the table knowing something. So perhaps it will provoke him or her to study the case and um, learn what bills of exchange is to an extent where he can be competent and bring up his level of the degree of knowledge based upon the case. And maybe once he's heard your oral arguments, that will assist him in a real life example. So we don't want to say, oh, a judge that never did bills of exchange, oh, I wouldn't want him. He may be the most open minded. Maybe the other judges have been practicing illegal rulings on bills of exchange. Maybe they are familiar with it, but they have been indulging in legal practices of uh, uh, making judgments against people with affirmed affidavits, uh, with facts and evidence to substantiate those facts. Well, there that in that case, in no way should that be ignored, dismissed, or denied, and not in no way, because that meets all the criteria. And then they allow people to admit statements on the record. A statement ain't shit. A statement is not a bona fide document. That's why all court documents is affidavits. When you fill out the form for the internal affairs, the form is an affidavit, and then you signed it under a sworn or firm authority, meaning you're gonna stand by your word. That's what the jurat. It's gonna have you a jurat on there. It's an affidavit. Please believe. I don't care if it look like an application to a job or application to this and application to that. If it got a jurat to it, it is an application. But the type of application that it is bona fide by the signator of this the person who signed it is the one who's the binding creditor of that instrument. And so we got to understand that when you signed it, that was your document, not theirs. You be like, I signed y'all application. I filled out y'all application. That wasn't their application per se, because it had their name on it. They deceived you into thinking it was their application. But if it was their application, then why didn't they sign it? Hmm. Let that marinate a little while. If it's their application, then why didn't they sign it? Y'all think about that. Let that marinate a little while. That was your application. Why do you think when it says it's my FICO score, okay? It don't say your FICO score. It say my FICO score because they want you to take ownership of it. That's not my FICO score. That's their FICO score. I don't have a FICO score. They have a FICO score of me. I don't have a FICO score. My credit is good. I'm a secured party credit. So the only thing I could do is say that uh, perhaps their information needs to be um, validated by the source, which is me. And when I send letters as such. I am the original creditor. I don't need you to validate nothing. I need you to correct this matter. Perhaps you were mistaken. Somebody send me a letter talking about they validated something. First of all, I didn't ask you to validate. That was somebody else. You mixed me up with somebody else. I didn't ask you to validate nothing. Why would I ask you to validate something you can't validate? That would be dumb. I am the only one who can validate or invalidate the claim, and I already invalidated and said you are mistaken. on what these terms and agreements actually consist of and the who's who in this contract. So please know that if you really had some power or some not power, some understanding, like people say knowledge is power, that's why I said power. Real knowledge, real understanding, real power. It don't have to have a whole harmless contract because they're not gonna be cause no harm. When you doing the right thing, you're not gonna cause no harm. People only have to have a whole harmless uh, contract because somebody is in that uh, entity is some kind of way in their structure. Something is a little bit shaky. You saying you don't want me to hold you responsible? I know you can't be responsible for everybody's actions, but you is responsible if you release this product where it can be harmful. So your whole harmless clause is void. I don't care if you got a whole harmless clause. It can be voided because the actions got to back it up. You got to be able to show that you really didn't have responsibility for whatever went down that causes some liability to the principal. And that whole harmless uh, clause don't apply to the principal. That apply to um, the shareholders. That don't apply to the principal. Let's be clear. That do not apply to the principal. The principal holder has rights that I don't care what kind of policy and procedure you try to write, it don't ever rule out the principal right. That's why we started out having videos and uh, broadcast definition type broadcast to help people understand words first. Trying to jump into reading, you don't understand that words have different meanings. Get that understood. And when it's being used, it may have a totally different meaning than what you think. That's like a lot of people want to jump and do OIDs and don't know what an OID is. You want to run and jump and do a 1099A, and you don't know what a 1099A is. I barely know about its species, but I've been studying it for quite a while. Now I understand its species. It's a trademark. It's an IRS trademark, especially with the uh, massive requests that are coming in from the sovereign community for these documents. Do you know we have created a whole different spectrum where other people are seeing the implications of these documents that they didn't even see for themselves at first because people are using these documents and saying This is the way you use this document. This is the way I used it, and they let my shit go through. Not knowing because it was an original way they allowed it, and they allowed it through because it was an idea for them. At the same time, if they really want to use the idea for themselves and trademark that process, they'll prosecute you for doing it so that they're free to do your process. Take your copyright, the patent to it, because of how you went about doing it and didn't know your rights to the document. Just like um, that man who made U.S. Treasury um, money orders. Well, the U.S. Treasury um, wouldn't be able to make money orders in the future, or they would really be responsible for basically taking that man idea and prosecuted him for it and then used it in commerce. What they were supposed to have done was offered that man a deal and said, we ain't never even think of this, but it would be good if we could issue, you know, different formats of currency that people will bona fide as authentic. Okay, but I think they have some kind of agreement that they can't just take over all the markets and just because they already got the monopoly on people thinking that the dollar is a money. Okay, it's legal tender, but it is not. It's legal tender, but it's not lawful money because it's a difference between legal tender and lawful money. Um, if you have a painting you drew, okay, and you wonder why I use the painting, well, painting is on a canvas that's whole cloth. You wrote on it with whatever your pastels or whatever type of ink you used, okay, to write on it, and then you signed it. That is a bill of exchange. It's something that you can use to exchange for money. It is no different than a dollar bill. They take some cloth and they press out these units, and they have increments of value that they have already pre-selected. This is one note. This is 5 notes. This is uh, 10 notes in one. Okay? And people never even think about that. You know, well, what does it mean to have a dollar? What is a dollar? What is a dollar? Exchange of a value in the amount that's what is given the consideration by the people, by the parties that are making the exchange. It's just like bartering. You only value that money because the other person value it, right? You may have value in other things, but you're making an exchange with that person with money because it's a common um, practice to give the person, We give it all kinds of names: greenbacks, paper bill, dollar bill, all kinds of little names. There's none of that is on there. That's a Federal Reserve note. Okay, so the understanding of what it is already a monopoly that they're holding. So they might not be able to legally and lawfully hold a stake in money orders. Okay, because that's all they're doing is money orders from the principals, and we don't want to commingle. We got to understand who's sending these money orders and who can send these money orders, and why was your presentment improper. Okay, it was improper because you know, and then the person examining it got to know all of the becauses to even give you a sufficient answer, understanding of what has gone awry here. What has gone awry with these 1099A explainers? You cannot explain nothing you don't even understand. Y'all just seen that on the video. Just rewind, go back. You'll see. We started watching this video, okay? And I don't even think we was about halfway through before I was ready to stop the video. First of all, you got commercials interrupting. You ain't even said nothing yet, and you got a commercial going. Say something, draw me in first. You got a commercial going 2 seconds in, you ain't said shit. Made me want to cut the motherfucker off. People need to stop playing silly games. This is people's life. People is going to jail behind filling out these 1099A. Don't make no sense for you to even be representing anything explained how to use it to take control of nothing. Because you're not even in control of your own damn self. That's part one. How are you going to take control of anything else if you're not in control of your own self? You're out here in these streets trying to offer information. You still a minor. How you going to explain something? And then got under the guise of a channel titled University. What's this, the Universal You Learn From Me program? What are we doing in these streets? And he flipped around and said he had knowledge of it, but after he had just said he ain't never done it. How can you do both? You cannot do both. You do not have first-hand knowledge. I'm not trying to hear nothing you got to say, buddy. And that don't have nothing to do with disrespecting you as a man. You was not being honorable as a man. You acted in dishonor with this here. And having nerve enough to try to sell somebody a program and stuff like that. Y'all need to cut it. Cut it. Cut it. Cut it. Cut it. Cut it. Now, we laced y'all up with a little bit of uh, um, the content from Mansa channel. Go over there and subscribe. Now, I go forewarn you. You gonna be saying a lot of crazy shit, but hang in there. That's worth it. If you ain't got shit else to do, you like a little crazy shit, he got a little of both for you over there. So that's why his channel blows up. He'd shut his shit down and blow right back up. Yeah, because he on a set path. You can't just be rocking to and fro. You need to be on a set path, on a certain set journey. Understanding, knowing what you're doing when you saying, I am not a minor. Okay, well, you shouldn't be acting like a minor if you're not a minor. You shouldn't have to tell me you're not a minor. You'll be doing things that show me that you are not a minor. What they say, actions speak louder than words. That's on the one. And the two and the four is this. How Patrick Devine say you need to go back to learn your ABCs. That means you need to learn the basics. Okay? Get on down to the basics. And when it come down to these documents, before you even get to your ABCs, right? You have to learn your manners. Think about it. You have to learn your code of conduct. Think about it. Before your parents even ever taught you your ABCs and your one, two, threes later on, okay, in that order. But what preceded that? What? You learned how to eat. You learned how to use the bathroom. Probably before you start speaking, or simultaneously somewhere around in between. But nonetheless, the point is you learn all the natural things, the rules first. You learn not to buck mama or she'll pop that head. You learn all the natural things first. You learn code of conduct, what to do, what not to do. Mama say, come on, it's time for you to get your clothes on. You gonna stop that kicking because she gonna tap that leg. Hey, stop kicking. Let me put your leg in here. You wasting my time. I'm trying to get you ready for school. I'm trying to get you ready to take you to daycare. And even though that child can't even supposedly understand that parent, what they do, they stop kicking them legs. Because the understanding was relayed depending on how fervent the parent is in relaying the understanding. Whether you can talk back to me and like correspond with me in kind or not is not determined does not determine whether you can understand what I'm saying to you. It's just like a dog. You can train him in any language because he don't need to know your language to understand what you're saying to him. He not learning the language. He learning the understanding of what this means. When you react in this manner, he's learning what does that mean. Body language is what they call it. And so we got to understand body language first. And the body of the law, what covers the body of the language. Period. Body of language. Period. Because we saying remedy, people got remedy, and they don't even know what remedy is. They don't even know how to write out fact to be able to verbalize a remedy. You have to be able to make factual statements to calculate remedy. You just can't hurl out accusations, say these people owe me, da da da. No, you got to say why I experienced loss and damage in the sum of $8 million due to the negligence of, the responsible parties in this matter. Who are the responsible parties? The responsible parties are the defendants. That's who the damn responsible parties are. Let's be clear. But you got to be clear. On a 1099-8, if you're intending to use the form in a unique manner, give notice to that. Also, let the person know you would like to correct that if in any way that it contradicts, the use of the form, the proper use of the form, and that was intended by, the person who has the copyright to the form. Otherwise, just don't use the form. Just create your own form and let them know that's what you're doing. See attachment for this information. But remain in honor. In any case, remain in honor. And there's always a way to remain in honor. First and foremost, ask questions. I ask questions. I want you to give me a lie on the record. It'd be nice if you can just give me a good old lie on the record. I told, because that's evidence against them. That's why you want them to go ahead and tell. You don't want them to lie. That's a choice that they made. They speaking for themselves. You didn't tell them, here, I'm going to record you lie on the record when I ask you these questions. That's a choice they making. And they just so in the habit of doing it. And so you just happen to catch them on the record doing it. That's all. And then utilize that record to your benefit. Because they've been getting away with it because nobody don't have no record of it. Because they tell you they record. Why can't you record them? I don't see why not. And I'll tell them, they'll say this phone called me. I'll say, yes, it is. I agree. It is being recorded. You don't mind if I record, do you? You record. I need to record this interaction, communication, because we're going to discuss some serious matters here. Now, are you saying on the record that this company is not a securitized corporation? A company that indulges in securitization of notes? Is that what you're saying? Oh no, all I'm saying is your account don't have nothing to do with that. Oh really? So what you're stating on the record is, in fact, that none of my accounts have anything to do with the securitization of pooling instruments. Oh, yes, all the customers, but they in different ones. Well, what does that matter? That means you got me in one of them, right? So the whole point was to avoid the direct question. it has my account been application been utilized in a security instrument? Have it been used or not? Is the question. Yes, but that on, and they'll hurry up and say yes, but I got that on the record already, and then I'm gonna point it out after I get the yes. So you're saying yes, but that don't have nothing to do with my phone number either. That's not another account. No, ma'am. As I can see, you only got one account. Oh, really? Well, judging from our conversation, we just had discussed at least two. We just judging from the conversation, we have already discussed two level of interest. I filled out an application, and I provided for services. So that was an exchange of goods and an exchange of services. It was a purchase agreement, and then there was the terms of service. That two separate contracts that occurred there. If I'm not mistaken, I don't think I'm mistaken at all. They no longer want to discuss this matter with me. They claim that I'm badgering them and so forth like that to try to escape questioning. When they do that, that lets you know that they have no intentions. And then I even asked to speak to the shareholders department. If in fact that what you claim declassifies me when I know that shareholders have superior interests. And so you telling me that makes me a shareholder, transfer me to a shareholder department. I'm not just a consumer, I'm a shareholder. Yes, I can be both a consumer and a shareholder. It's how you buy stocks in Apple and then you may purchase an Apple phone. Okay? You purchase this. That made you um, have so many different contracts with Apple that it's ridiculous. It's not just with the way that they're pretending you get your iCloud and you just have one account. That's the way they're making you believe. But you got gazillions of accounts that's being traded on if you have an account with Apple. And I do. And it's for my creative property. So I know I got gazillions of accounts with them. Okay, but people need to understand that each aspect is an account. Why do you think each area has a field? Okay, to determine what type of structural agreement or settlement are we arranging here? What is the performance on this contract? What is the performance agreement? Well, we agree we will make content for YouTube videos. That is a contract on its face. YouTube would provide us the technological means to do that with some level of ease, not having the knowledge to build programs and kernels and so forth, coding and so forth to do it for ourselves. So that's what they're providing for you to make it easy. Services. It's not a product. You are the product. We're going to stop right there and let y'all marinate on that just a bit because we got to get an understanding before we dive into the 1099A acquisition.